For the rational study of the law, the black-letter man may be the man of the present, but the man of the future is the man of statistics and the master of economics. Oliver Wendell Holmes spoke those words in 1897. For 2,000 years, lawmakers and judges answered questions about human behavior much as the Romans did, by consulting their intuition and available facts. Before 1960, the Legal Academy restricted economics to explicitly financial topics, to antitrust law, to regulated industries, and the capital gains tax. In the early 1960s, Ronald Coase and Guido Calabresi broke those boundaries. They demonstrated that economics had found a vacant niche in the intellectual ecology of traditional law, and it rapidly filled it. Law is a social institution of enormous antiquity. Economics provided it with a scientific theory to predict how people actually respond to state sanctions. This approach moved legal scholarship from cataloging rules to building predictive models. By the 1990s, the transition was so complete that at least one economist sat on the faculty of every top law school in North America. To an economist, a state-backed legal sanction operates as an implicit price attached to a specific behavior. People respond to these sanctions exactly as they respond to market prices, increase the cost of an activity, and they engage in less of it. This analysis utilizes price theory and game theory for its models, testing them with the tools of statistics and econometrics. For a firm choosing product safety level S, total cost is C of S, manufacturing cost, plus L of S, expected liability and lost demand. The firm minimizes cost by setting the marginal cost of additional safety equal to the marginal benefit from reduced liability. That single crossing point is the mathematical seed of the famous hand formula students encounter in tort law. The firm pushes safety only to the point where $1 more of caution buys exactly $1 of avoided liability. Optimal legal rules, in this view, prioritize efficiency over perfect safety. We can apply this framework to a criminal sentencing commission trying to establish the optimal fine to deter rational white-collar crime. The expected cost of crime is the probability of being caught, P, multiplied by the magnitude of the fine, F. Halve the odds of being caught, but double the fine, and the rational criminal faces the exact same expected cost. Deterrence is held constant. Producing probability through police and auditors is highly expensive. Writing a larger number on a judgment is virtually free. Gary Becker's Nobel-cited solution minimizes state costs by dropping detection probability and pushing fines toward the offender's total wealth. This corner solution assumes criminals are risk-neutral. If they are risk-averse or insolvent, the math breaks, which is why modern models often return to the high cost of imprisonment. These models allow the state to maintain a target level of safety while minimizing the dead-weight loss of the justice system itself. In contract law, imagine a company contracted to deliver oil, but war in the Middle East suddenly breaks out, making delivery impossible. Because the contract is silent on the risk of war, the court must decide who bears the loss of the manufacturer's profits. The judge is simultaneously resolving this specific dispute and creating a rule for every future party in similar circumstances. Efficiency suggests the court should assign the risk to the least cost risk bearer. Since the oil company operates in the Middle East, it is better situated to assess and hedge that risk than a European manufacturer. By assigning liability to the party who can prevent or insure against the harm most cheaply, the judge writes a forward-looking price for precaution into the law. Consider property law. Eddie's Electric emits smoke that dirties the wash at Lucille's laundry. Eddie can install scrubbers at cost S, or Lucille can install filters at cost F. In this scenario, filters are cheaper. If the neighbors cannot bargain, the judge rules against Lucille, so she installs the filters. Without communication, the legal rule does the allocative work. But the Coase theorem shows that if they bargain without cost, they will always choose the cheaper filters and split the gain, regardless of the ruling. The real lesson is the contrapositive. Because transaction costs in the real world are never zero, the initial legal rule almost always determines the final outcome. This transforms property law. The law's job is to place the entitlement to minimize the sum of the harm and the transaction costs, effectively mimicking the bargain the parties would have struck. Rights are no longer abstract moral claims. They are tools to minimize economic friction. Economists can model both the efficiency of a market and the distribution of income across social groups. This creates a central tension in legal design. The economic approach to private law proposes a controversial boundary that judges should optimize torts, contracts, and property exclusively for efficiency, leaving distributive justice to other systems. Imagine a rich desert oasis forced to share its ice cream with a poor one. A youth runs across the sand with a bowl, leaving a visible trail of drips behind. Those drips are Arthur Oaken's leaky bucket. They represent the deadweight cost of moving wealth from one group to another. Private law is a particularly leaky bucket. First, it targets groups imprecisely. Consumers are not always poor. Second, its effects are unpredictable, as corporations often pass liability costs back to consumers through higher prices. Third, legal transaction costs are high. Attorneys often absorb 2/3 of the stakes. Finally, these rules can distort the economy, like a tomato law that causes investors to withdraw from farming. The Kaplow-Chevelle argument suggests that the tax and transfer system can target inequality with more precision and less waste than reshuffling private rights. This prioritizes Kaldor-Hicks efficiency, which maximizes the total pie even if some individuals are left worse off. Critics like Daniel Farber and Chris Sancherico argue that efficiency cannot be the sole criterion for justice. The choice between equity and efficiency remains a value judgment, not a neutral fact. Despite the debate, the prevailing view in the field demands that judges use private law to maximize the total economic pie, leaving the legislature to decide how to slice it. Law needs economics to understand its behavioral consequences. Economics needs law to understand the underlying scaffolding of markets. When legal institutions of property and contract fail, as they did in the banking collapse of 2008, the economy follows. Economists provide lawyers with quantitative reasoning. Lawyers provide economists with institutional reality and names with moral resonance. Behavioral science is the mortar between the stones of the law. The black-letter man was the man of the present, but for the architect of the future, the master of economics has arrived.